Trump's empire is crumbling before our eyes. Federal judges across 3 jurisdictions just handed down coordinated rulings that could dismantle everything he's built over 5 decades. And this isn't political theater or partisan speculation. These are binding judicial orders targeting the financial foundation of his entire operation. When career judges appointed by both parties unite to strip protective corporate shields and freeze asset transfers, you know something catastrophic just happened. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this unprecedented judicial assault? A leaked 47-page memo from the Department of Justice dated January 31st alleges a coordinated scheme to shield assets through shell corporations while ongoing fraud investigations were actively underway. Sources who reviewed the document in a secure facility claim there were specific instructions to transfer property titles and dissolve holding companies just 72 hours before subpoenas were scheduled for service. This isn't another lawsuit that will drag through appeals for years. Federal judges have already issued preliminary orders with immediate effect. 3 separate courts in New York, Florida, and Washington, D.C. moved simultaneously on February 4th after prosecutors presented evidence of what they called systematic obstruction of justice. The Southern District of New York issued a temporary restraining order freezing all asset transfers from 17 corporate entities tied to Trump Organization holdings. Judge Sarah Martinez, a George W. Bush appointee with a reputation for strict adherence to precedent, stated in her written opinion that the evidence presented showed probable cause to believe assets were being deliberately concealed to frustrate legitimate legal proceedings. Meanwhile, in the D.C. District Court, Judge Robert Chen granted prosecutors emergency motion to appoint a special monitor with immediate access to all corporate financial records. The order specifically requires daily reporting of any transaction exceeding $50,000. And down in Florida, Judge Patricia Daniels issued what legal experts are calling the most aggressive ruling, piercing the corporate veil of 12 limited liability companies and holding Trump personally liable for their obligations. Smash that like button if this is making sense so far. Here's where it really gets serious. When federal judges from different jurisdictions coordinate timing on major rulings, it signals something bigger than routine legal proceedings. Sources close to the Department of Justice told reporters that prosecutors from all 3 districts held unprecedented joint strategy sessions throughout January, sharing evidence and synchronizing their approach. A former federal prosecutor with 30 years' experience told news outlets that this level of coordination only happens when authorities believe they're dealing with sophisticated efforts to hide assets across multiple states. The timeline is absolutely damning. On January 28th, court filings show that attorneys representing various Trump entities filed motions in all 3 jurisdictions, seeking to delay pending document production deadlines. The motions cited routine administrative burdens and requested 90-day extensions, but prosecutors had already obtained bank records through separate subpoenas showing unusual activity. Between January 15th and January 27th, property deeds were transferred, corporate registrations were amended, and over $200 million moved through accounts that had been dormant for years. When prosecutors presented this evidence in sealed emergency hearings on February 3rd, judges responded with immediate action. Court transcripts obtained by legal reporters reveal extraordinary exchanges. In the New York hearing, Judge Martinez directly questioned defense counsel about the timing of asset movements. When attorneys claimed the transfers were routine business decisions, she responded that the pattern showed consciousness of guilt. She stated from the bench that when 17 corporations simultaneously restructure just days before major legal deadlines, ordinary business explanations lose credibility. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. The D.C. ruling included language that should terrify anyone trying to protect assets through corporate structures. Judge Chen wrote that limited liability protections exist to encourage legitimate business activity, not to provide sanctuary for those seeking to defraud creditors or obstruct legal proceedings. He specifically found that corporate formalities had been so thoroughly disregarded that the entities function merely as Trump's alter ego. This is devastating because it eliminates the primary shield that has protected personal wealth from business liabilities for decades. Real estate experts estimate that piercing the corporate veil in this context could expose personal assets worth over $400 million to creditors and legal judgments. Property holdings in Manhattan, Palm Beach, and Bedminster that were considered untouchable because they were held through separate corporate entities are now directly vulnerable. But the Florida ruling might be even more catastrophic. Judge Daniels didn't just pierce the corporate veil. She appointed a receiver with authority to take immediate possession of 12 properties and manage them pending resolution of the underlying fraud claims. The receiver, a former federal bankruptcy trustee named Michael Richardson, filed his first status report on February 6th. That report detailed what he called a labyrinth of cross-ownership structures designed to obscure actual control and complicate any effort to trace asset flows. Richardson's report noted that corporate records were incomplete. Bank statements showed unexplained transfers totaling over $300 million in the past 18 months, and several properties had been assessed far below market value in financial statements submitted to lenders, while simultaneously being valued much higher in tax appeals. This isn't speculation from political opponents. This is a court-appointed officer with fiduciary duties describing what he found when he actually examined the records. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And here's what makes the situation exponentially worse. The coordination among these judges wasn't accidental. Legal experts reviewing the dockets noticed something extraordinary. All three courts received nearly identical emergency motions from prosecutors on February 2nd. The motions cited the same legal precedents, referenced overlapping evidence, and requested parallel relief. This suggests prosecutors across multiple districts had been building coordinated cases for months. A Harvard law professor who specializes in complex financial litigation told reporters that this approach is extremely rare and indicates prosecutors believe they have overwhelming evidence of a unified scheme. You don't coordinate across 3 federal districts unless you're confident the evidence will support aggressive judicial intervention. The professor noted that federal judges are naturally cautious about freezing assets or piercing corporate veils because these remedies can have devastating consequences if the underlying allegations prove unfounded. The fact that 3 experienced judges from different ideological backgrounds all granted emergency relief within 48 hours suggests the evidence presented was compelling. Former Attorney General sources told news outlets that the Justice Department's internal approval process for such coordinated action requires sign-off from the highest levels. This wasn't prosecutors in individual districts acting independently. This was a strategic decision reflecting confidence in the strength of the evidence and the legal theories. Don't go anywhere. The most explosive part is coming next, and here's what should alarm everyone following this story. The judicial orders don't just freeze current assets. They include clawback provisions targeting transfers made in the past 2 years. Judge Martinez's order specifically authorizes prosecutors to void any transaction that appears designed to place assets beyond the reach of creditors or legal judgments. This means property sales, corporate restructurings, and asset transfers completed months ago could be unwound. Legal experts call this fraudulent conveyance law, and it exists precisely to prevent people from hiding assets when they know legal trouble is coming. If prosecutors can prove that transfers were made with intent to hinder collection efforts, courts have authority to reverse those transactions and restore assets to their original position. The New York order identifies at least 9 specific transactions totaling over $150 million that prosecutors want reversed. One transaction stands out. On December 12, 2024, a Manhattan property held by Trump Organization LLC was transferred to a newly created Delaware corporation with no apparent business purpose. The property had been valued at $75 million on financial statements submitted to lenders, but the transfer documents listed the consideration as just $10. When questioned about this transaction during the February 3rd hearing, defense attorneys claimed it was an internal corporate reorganization with no tax consequences. Judge Martinez rejected that explanation. She noted that the timing, coming just 2 weeks before major investigative deadlines, combined with the nominal consideration and the use of a newly created entity, demonstrated all the hallmarks of an attempt to place the asset beyond reach. She ordered the transfer voided and the property restored to the original entity, now subject to the asset freeze. This pattern repeated across multiple transactions identified in the New York and Florida filings. Things escalated further when Trump's legal team filed emergency appeals in all 3 jurisdictions on February 5th. The appeals argued that the judicial orders were overly broad, violated due process, and would cause irreparable harm to ongoing business operations. But here's the problem with that argument. When you claim that freezing questionable asset transfers will cause irreparable harm, You're essentially admitting that your business model depends on continuing those transfers. The appeals courts in New York and D.C. denied the emergency motions within 24 hours. The Second Circuit panel wrote that the district court had properly exercised its discretion based on substantial evidence of ongoing efforts to dissipate assets. The D.C. Circuit was even more blunt, noting that claims of irreparable harm ring hollow when the alleged harm is simply being prevented from moving assets while fraud investigations proceed. If this blows your mind, hit that like button right now. Here's the situation facing the legal team. They're fighting simultaneous battles in 3 jurisdictions, with judges who have already signaled skepticism about the explanations offered for asset movements. The appointed receiver in Florida is now examining financial records and has authority to question executives under oath about transactions. The special monitor in D.C. is reviewing daily financial activity and filing weekly reports with the court. And the asset freeze in New York prevents any significant transaction without advance court approval. Former prosecutors who handled complex financial cases told reporters, "This is the worst possible scenario for any defendant. You're playing defense across multiple courts, judicial skepticism is already established, and independent officers with investigative authority are examining your records in real time. Every financial decision is now scrutinized, every corporate action requires justification, and any inconsistency in explanations across jurisdictions can be used against you in all of them." The political implications are staggering. While Trump faces various legal challenges, this cluster of judicial rulings strikes at something more fundamental than potential criminal liability. This threatens the financial structure that has sustained political operations, legal defense costs, and personal lifestyle for decades. Campaign finance experts noted that ongoing legal expenses from multiple investigations already exceed $5 million monthly. Those costs have been funded through a combination of political committees and business revenues. But if business operations are constrained by judicial oversight, if properties can't be leveraged or sold without court approval, if receivers and monitors are scrutinizing every transaction, the financial flexibility that enabled mounting expensive legal defenses could evaporate. A former campaign finance director told news networks that most people don't realize how expensive it is to fight coordinated legal challenges across multiple jurisdictions. Attorney fees alone can reach hundreds of thousands weekly when you're responding to subpoenas, filing motions, and attending hearings in several states simultaneously. And here's what makes it even more extraordinary. The judicial orders specifically prohibit using corporate funds to pay legal expenses related to the fraud investigations without advance court approval. Judge Chen's order in D.C. states that given the allegations of corporate assets being used for personal benefit, any substantial legal expenditures must be justified as legitimate business expenses. This creates an impossible situation. The investigations that triggered the asset freezes also make it difficult to use corporate resources to defend against those same investigations. Stay with me. What comes next will completely change how you view the situation. Legal scholars are already calling this a potential roadmap for how financial investigations can leverage civil court powers to constrain targets while criminal investigations proceed. The coordination among federal prosecutors, the willingness of judges to grant aggressive preliminary relief, and the appointment of independent officers to monitor compliance creates a framework that could be applied in other complex financial cases. A former federal judge told legal publications that these rulings reflect growing judicial impatience with sophisticated asset protection schemes. Courts have watched for years as wealthy individuals use corporate structures to shield assets from legal accountability. These orders signal that judges are willing to look beyond corporate formalities when evidence suggests those structures serve primarily to obstruct justice rather than conduct legitimate business. The timeline moving forward is absolutely critical. The receiver in Florida must file a comprehensive report by March 1st, detailing all assets under his control and recommending how they should be managed. The special monitor in D.C. has authority to recommend additional restrictions if monitoring reveals concerning patterns, and prosecutors in all 3 jurisdictions are continuing investigations with grand jury proceedings reportedly scheduled throughout February and March. Sources familiar with the investigations told reporters that the coordinated judicial orders were actually step 1 in a larger strategy. Prosecutors wanted to freeze the current financial picture before proceeding with additional legal action. With assets now locked down and independent officers monitoring activity, investigators can pursue the underlying fraud allegations without worrying that evidence will disappear or assets will be moved beyond reach. Here's what multiple legal experts emphasize. These judicial rulings are preliminary. They're based on prosecutors showing probable cause and demonstrating risk of asset dissipation. The ultimate question of whether fraud actually occurred will be decided through full proceedings with discovery, testimony, and detailed examination of evidence. But preliminary relief in civil cases doesn't require proof beyond reasonable doubt. It requires showing a likelihood of success and risk of irreparable harm. 3 federal judges concluded that prosecutors met that burden. They found sufficient evidence to believe assets were being moved to avoid legal accountability and sufficient risk that without immediate intervention, those assets would be placed beyond the court's reach. Whether the underlying fraud allegations ultimately prove true will be determined through lengthy legal proceedings. But in the meantime, the financial empire is operating under unprecedented judicial oversight. Pause for a second and hit that like button if you're finding value in this coverage. Here's where things stand right now. 3 federal judges have issued coordinated orders freezing assets, piercing corporate protections, and appointing independent officers to monitor financial activity. Appeals have been denied. Receivers and monitors are examining records, and prosecutors are continuing investigations that could result in additional legal action. This isn't another news cycle that will fade away. This is a fundamental shift in how courts are willing to address sophisticated asset protection schemes when prosecutors present evidence of obstruction. The financial structure that sustained operations for decades is now operating under judicial supervision. Every significant transaction requires court approval. Independent officers are scrutinizing records and questioning executives. And the protective corporate shields that made personal assets untouchable have been eliminated in multiple jurisdictions. What happens next could determine whether complex corporate structures can successfully shield personal wealth from legal accountability when evidence suggests those structures serve primarily to obstruct justice. The judicial orders are clear, the oversight is immediate, and the financial constraints are unprecedented. Keep watching this story closely because the implications extend far beyond one individual. This could reshape how courts approach asset protection schemes across the country. The stakes have never been higher, the judicial intervention has never been more aggressive, and the financial empire has never been more vulnerable.